case that started in the United States as a Reza Zarrab case and was later turned into a Hakan Atilla case, concluded last week with the verdict of the jury. The jury found former Halkbank Deputy General Manager Hakan Atilla guilty of 5 out of the 6 counts he was charged with by the prosecution. The only charge he was acquitted of was money laundering. There is no point in blaming the jury instead of the court itself, who took over a case they had no business in to start with. The jury evaluated the case they were presented based on its content. A brief study on how the jury work in the United States is enough to understand how problematic their justice system is. This system deserves to be analyzed, particularly in terms of sociology of law, the existing date on the selection of jurors, and the kind of sociological, psychological, and ideological factors they work under shows how the jury system in the United States has been turned into a weak link in order to distort justice with manipulation. But our topic is not that for now. Of course, our interest on the shortcomings of the system is overshadowed by the fact that the judge of the case was entertained by the FETÖ terrorist organization members with great hospitality in Istanbul in May 2014. The case was comprised of information and documentation that was forged during the December 17 and 25 operation of FETÖ, the United States political theology tricks. The point is how an event that occurred in Turkey was moved to the United States with this lawsuit, and with what nations the United States courts open on this case. Without a doubt, opening this case is a power play before everything, because to be able to judge is a power climb. The act of feeling, admitting, and sustaining the case is a power struggle in the United States. The Constitutional Court of the Republic of Turkey used it to conduct this power play on behalf of itself and its ally powerhouses by accepting cases which they had no business with and which were out of its jurisdiction according to the Constitution itself. By providing such acceptation in the clear texts of the Constitution, they use it to remind everyone who the sovereign was, and members of the Republican People's Party desperately used this as their only haven for their power. The Constitutional Court would make everyone feel the existence of the deep power they represented in action by saying it's all said and done with their decisions. In this case being tried in the United States, when this situation that has no precedent in law is declared as an exception that will encompass the sovereignty claim, it actually evokes the basic de facto rule of the political theology. The sovereign can make and implement exceptions. The United States wants to remind Turkey who the sovereign is by entering and area that belongs to Turkey. While doing this, they disregard the impracticability of the law and their relationship with the Turkey. There is no point in pretending to not understand how they do it. The United States does this intentionally. It is a show of power and an attempt to remind Turkey of the relationship they think they need to have. Why does the United States feel the need to do this? Of course, it is not hard to predict. For a long time, Turkey has been operating by accepting submission to the United States. Turkey heavily depended on the United States and did not do anything in foreign relations that might overstep the United States, but Turkey paid its debt to the International Monetary Foundation (IMF) to the last cent without being subjected to the tutelage of IMF in determining financial policies. In fact, Turkey offered to lend money to the IMF. In the Paris, Davos, and the Marmara incidents, Turkey burned its bridges with Israel and extension of the United States in the Middle East and distanced itself from the role the United States wanted Turkey to assume. Of course, this was to be punished sooner rather than later. The incidents of February 7, Gezi protests, December 17 and 25, and July 15 were attempts of punishment and obstruction against the state making its own decisions. After Turkey's leader Recep Tayyip Erdogan, Excellency, and his Justice and Development Party emerged from all these, even more powerful, the United States once again wanted to remind Turkey of the roles that were agreed on a long time ago. The fact that the content of the case is completely the same with the December 17 and 25 attempt alone blatantly shows those who were behind December 17 and 25 and therefore all other operations and co-patents. The fact that the United States tries to bring Turkey to its knees with this case shows that they are losing all their leverage after doing everything they could do to Turkey with political theology tricks, because it is a sign of exhaustion, exploiting their own law system and making exceptions for political ambitions. Thanks God, today's Turkey does not bow to the fake god of this or produce this political theology that accurate submission and obedience. However, we should also point out that those who want to take advantage of this case, which was clearly open to bring Turkey to its knees, accepts and allows to the United States claims of being the sovereign and master of Turkey. After pointing that out, we should also point out that when we talk about America, we are not talking about a united America that approached every issue from the same perspective and can act from one center. The United States is a market where parallel elements can influence by means of money and lobbies, and equal opportunities are offered to everyone on this matter. Today we face a typical example of an operation by a group that is influenced by FETÖ terrorist organization using all aid, revenues, and lobby works, and what sort of a quagmire the United States justice system was sucked into through this kind of infiltrations. Thank you very much for listening, and God bless you all, my dear brothers and sisters.